Good morning. Welcome to Fair Housing and Equal Access, a Rural Nevada COC TA session. This is the fourth one in the series related to coordinated entry. This is being recorded for future folks and anybody who can't join us today. So we're just going to get started. So I work at Homebase, and my co-presenter, Erica McWhorter, also works at Homebase. We're a nonprofit based in California, and we help communities and agencies better respond to homelessness. A few logistics. Everyone's muted as they come in to maintain sound quality and recording quality. If you have questions, you can type them in the chat box, and we'll be happy to respond. And if you have technical issues, if you select Bridget or Erica, then we'll know that you're chatting with us about something. We'll try and get it fixed. I hope everyone can hear me right now. If you could you, someone just put a little note if you can hear me, everything's going okay in the chat. It's you might find it in the three little numbers in the more, or three little dots in the more. Thanks, Tori. All right, great. Because everyone's in listen only mode, you can either type in your comments during Q&A, or you can unmute yourself using these instructions. Either if you're on phone, press *6, or on the computer, unmute using the microphone and speak up and ask your question out loud. If you need help with that, you can also ask a question in the chat box, and we'll be glad to help you. So our agenda for today is that we're going to talk about fair housing and the equal access rule and how that coordinates with coordinated entry. The idea is that there's often, when we're talking about housing first and ideas like that and coordinated entry, we talk about barriers to housing. And sometimes they're more than barriers, sometimes they're discrimination. And so we're going to talk about what are the requirements for housers, for housing providers or landlords, for housing providers who are funded by continuum of care or ESG or other funding, and identifying when it rises to the level of discrimination, and then what to do about it, and some of the requirements that are held. Hopefully that's what you came to hear today. I'm going to do a quick poll about what's your role related to coordinated entry. If you wouldn't mind filling that out for us, so we've got some kind of idea of who we're chatting with today. So it could be a little general because this is also for people in the future, but. All right. Thank you. All right. And then our goals for today are to share information about the federal requirements related to fair housing, review some best practices and examples of prohibited conduct, and then talk about the COC's policies that are related to these ideas. So let's start with fair housing. And Erica, you want to take this over?
Sure, sorry about that. Today it's important to understand that two of the major federal regulations, we're going to be speaking about two of the major federal regulations that correspond with making sure that discrimination and grievances are appropriately handled, includes fair housing. Now, this is one of the ones that you can go to the next slide, please, Bridget. Sorry about that. This is one of the ones that is most well known. And just to give everyone an idea of what the basics are, it prohibits discrimination in any housing related activity. This includes housing services, such as case management, housing navigation, as well as in the actual rentals of and purchases of housing itself. So it doesn't just apply to landlords. That's the important takeaway. This can include refusing to rent to someone, steering people to a specific type of housing, a specific neighborhood, and because of their membership in a specific group, or because of their particular status. And under the Fair Housing Law, these protected statuses, or these special groups that are protected from discrimination, include race, color, national origin, disability, sex, religion, and family status. Most states also have other specifics that they look at, or other statuses that are protected under state law. And in Nevada, that includes their ancestry, sexual orientation, and gender identity or expression. Next slide, please. So what exactly is the Fair Housing Act designed to do? It's designed to make sure that there is not any kind of differential treatment or intentional discrimination that targets specific classes, the ones we just spoke about, and that all residents are treated similarly. So any policies, any activities must treat residents the same. And that's what's meant by discrimination on the basis of disparate treatment. So it cannot have a discriminatory intent or impact. And this is intended to make sure that it's not just blatant discrimination, or discrimination that's intended to be something that's racist or sexist. That's not the only thing that this covers. So for instance, disparate treatment, or treating people differently, that could include treating people different in terms of what you say is available to them, what you do after they ask for something specific, so in the form of retaliation or harassment, or the failure to make what's called reasonable accommodations. And we'll speak a little bit more about what reasonable accommodations means in a little bit. Next slide, please. So discrimination is also, can also be discrimination based on impact. So this is, again, that part of discrimination that that might create unintended consequences. So if you're not intending to discriminate, but the policy tends to have a specific or greater effect on certain people, particularly people in those protected classes, then it is considered discriminatory. So it's very important that any housing and shelter providers review all their policies, rules, procedures, eligibility requirements, etc., to determine if their policies and practices, even unintentionally, could result in members of the protected class being treated differently. So just some kind of examples that come up, and you can go to the next slide, Bridget, are refusals to rent or sell because of one's protected status. And that could look like something along the lines of telling a qualified applicant that units are not available when they are available. Making people feel not particularly welcome, discriminatory statements, delaying tactics such as manipulating wait lists or delaying action on applications, and refusing to show or sell, or show or rent a particular unit. It could also be in the way that you describe what unit is available, for instance, or what kinds of eligibility requirements are on the unit. So for instance, saying these units cannot be rented to domestic violence survivors. That would have a disproportionate impact on women, but it also would have a disproportionate impact on, could also have a disproportionate impact on families with children. So the same goes for units or procedures that describe housing where no one can play outside. That tends to have a disproportionate impact on families with children. Of course, segregation, and this can be tricky. This doesn't always mean, people of color go to some neighborhoods, and or people who have a certain sexual orientation go to certain units. This could also include segregating residents by sex, and when they have shared sleeping areas, so bathing areas and bathrooms, which could negatively influence the residents' right to privacy. The thing to remember about this is that—
Can you clarify that real quick? You can segregate by sex if there's shared sleeping bathrooms.
Yes.
But you can't if there's not.
That's correct.
Right.
That's correct. So so that could negatively influence a resident's right to privacy. So it's important that that any rentals or any policies that are intended to discuss segregating or moving people around on the basis of sex, it doesn't necessarily dictate things like sleeping arrangements, especially because this could trigger the Fair Housing Act's discrimination and non-discrimination requirements. So the next thing I want to note here is that this also, what this applies to. So any building, unit, structure designed for occupancy or dwelling is what this applies to. It also applies to advertising. So it's important to remember that even if your property is exempt from the Fair Housing Act because of some exception, and we'll get to some of those soon, shortly, you're still required to make sure your advertising is not discriminatory. The scope of this act also goes beyond just housing. It goes beyond just landlords. So for instance, any traditional housing. So you have shelters, single room occupancy units. Sometimes hotels or motels are converted into those. Group homes, any service provider or social service provider dealing with housing. Rentals, any real estate transactions. This applies to the housing authorities. And so the way you determine whether or not this is applicable is usually on a case-by-case basis, but you kind of look at a number of factors. And those factors include things like the length of the stay. If this particular unit is intended to have people stay for a certain length of time or a lengthy period of time. The amenities that are included, is there a phone, mailing address, how the property is marketed. Is this marketed as something where someone could, where this is considered a dwelling? Whether there's rental payments, other fees or in-kind services for staying there. That all also goes to the applicable scope of this fair housing rule. So some non-traditional housing that's covered under the fair housing laws also can include things like clean and sober housing and group homes. Sometimes people don't necessarily think of those as being covered, but they're covered as well. Next slide, please. With respect to some special populations that you need to consider when you're thinking in terms of what's discriminatory and what's not. Sometimes going overboard in one direction to try and make sure you have housing for a specific population can also be run afoul of these rules. So for instance, when you're serving persons with disabilities, it's important to understand that only certain housing programs are explicitly authorized to grant preferences to people who have specific disabilities, pursuant to federal statutes or executive orders. And this includes things like Section 8, HOPWA. And so it's important that when there are preferences, the housing, that while the housing may offer services for a specific type of disability, no otherwise eligible individual that has a disability or a family that includes a disability that could benefit from the services can be excluded. So you don't have to have a particular disability in order to be served in those units. So be very cautious when trying to limit those units to specific disabilities, especially if it's clear that someone with another disability could possibly benefit. So just a clarifying example. So say there is a private nonprofit organization or local government who applies for and receives COC grant funding to provide rental assistance and services such as case management or therapy, and they can establish, the recipient or subrecipient of that COC program funds can establish a preference for individuals who are chronically homeless. So when filling their openings for the housing, the recipient or sub could target chronically homeless individuals or families. But if there aren't any people who are on the wait list or who apply for entry into the program, the sub cannot, or the recipient or the sub-recipient of those funds cannot deny occupancy to people who apply for entrance into the program and who may benefit from those services. So when filling the vacancy, if you're presented with two otherwise eligible persons, one who is chronically homeless and one who is not, then you can give a preference. So that's to help kind of guide that decision making. Same thing goes for how housing authorities could do this and how housing choice vouchers work. Next slide, please. So another population to be cautious about when thinking through what is lawful to do when serving pregnant households and persons with children. It's important to understand that based on the family status, that is a protected status. So if there is one or more children under the age of 18 in a household, there are some exceptions to this. So if the size of the unit or sleeping area is only sufficient for a single individual, such as like a cot in a dormitory or an SRO unit, a single room occupancy unit, then you don't have to try and serve these particular people through that particular service. Another common exception is senior housing. So senior housing does have a special exception carved out in this rule. So if you have senior housing available, this is one of the reasons why you don't have to permit families with children from living in that senior housing. It's okay to restrict that. Another exception is housing that's targeted at individuals being released from correctional institutions. So for instance, sex offenders, you may be able to designate special housing for sex offenders and then exclude families with children from living in that sort of housing. So that can get a little tricky too. So if there is a circumstance where something like that particular exception may apply, you want to double check with legal counsel and definitely with the RNCoC steering committee for how to go about making sure that the policies and the activity and the advertising comports with this rule. One other thing to note here is when you're serving domestic violence survivors and families with that history. So providers who house domestic violence survivors and their children should not think that they should refuse or can refuse to house women with sons under 18. So just because there is a male in the household under 18 doesn't mean that they should be excluded from housing specific to domestic violence survivors. That's come up in other locations, and we just want to be clear about that. Also, and this goes back to the clarification that Bridget helped provide in an earlier slide. If there are not shared sleeping or bathing areas or shared bathrooms, such policies are probably illegal when trying to kind of segregate some of these families. So where there are shared sleeping or bathing areas, providers should instead consider if there is a way to modify floor plans to provide privacy. The other thing to kind of consider is if there is a family with teenage sons who are turned away from or who the provider is considering turning away from domestic violence housing, then try to find an alternative lodging or alternative services that the family could then go ahead and take advantage of, just because you don't want to unintentionally discriminate against the family as a result of them having males in their household. There are compelling reasons to exclude adult men from domestic violence shelters due to privacy concerns, as we kind of spoke about earlier. But communities should have a mechanism in place for serving survivors of domestic violence who are male. So whether you're providing motel vouchers with corresponding counseling services, or just kind of cobbling together some other form of resources for that individual or those families, that's the best way to go about serving those domestic violence survivors if there's concerns about privacy or safety. Next slide, please. So screening and admissions criteria. So this applies not just to landlords, but also to the housing services providers who are considering placing people into housing. So any criteria related to screening and admissions should have clear and objective criteria and avoid using any kind of factors that could be subjective. So for instance, what does objective criteria include? Rental history. So this is something that's easily documented that you can see. That could be something like the number of stays in shelters and hospitals or other alternative housing arrangements. Another objective factor would be something like amount of income. That's easily documented. Providers can't discriminate against applicants based on their source of income, such as child support or SSDI, so long as the income is not from illegal activity. Another way to think about objective criteria is observable behavior. So it's permissible to decline to serve a person if they are acting in a violent manner towards staff who are handling the intake. That's easily observable. That's not like we think they might be violent. We've seen it happen. Another objective criteria that can be used is recommendations for by referral agencies and programs such as social services or mental health or law enforcement, so long as those other programs do not have discriminatory practices and that their recommendations are based on objective criteria. And so that kind of requires that when you're taking those referrals, that you're also asking the right questions, or that you have an idea of how the person or entity referring those people operates, which is why it's important to know what the other providers have in terms of their own policies and procedures. And that's something that can be done on a system-wide level, not necessarily program by program. So in thinking about like the wrong things to consider, these subjective factors, that would be things like odd behaviors. They were acting odd instead of something specific, like they were a threat to others because they threatened to punch them or they lunged at people. Also, try avoiding making these decisions about screening and admissions on the basis of like intuitive senses. Thinking in terms of, well, we're willing to commit someone to, we're willing to accept someone into a program if we think that they will get along well with others, or if we don't want to because they seem shady or untrustworthy. It can't be a gut reaction. Individuals with disabilities or gender identities sometimes pose some challenging situations, such as the need for private restrooms. That in knowing that ahead of time, that's an insufficient reason to just say, well, we probably shouldn't put you there. However, you can take additional time to kind of consider some of those factors in terms of whether or not the place is, whether or not that individual may need additional reasonable accommodations in order to be there. And reasonable accommodations is next. So this whole time we've been talking about all of the things that you cannot do and all of the things that are prohibited. But what happens if, what happens next? That's really the next question. Do you just turn someone away? The answer to that is you do not turn someone away. You do not just avoid working with a person if there's a way to make a change to policy, provide an exception to the practice, or make an adjustment to the service, which would allow the person or household to otherwise use and enjoy the services or the housing. And so this is very much a case-by-case basis. There's a lot of ifs, ands, and buts that come with this, but let's just start off by kind of thinking about what would be things that reasonable accommodations just might not be available for. So if you come to a situation where there seems to be, like, this could possibly be considered discrimination, we cannot serve this person or this household for some reason, there are certain things that it's okay to just kind of stop the analysis there and say, this is just not possible at this time for this particular unit or this particular service. And those kind of factors for denial include things like undue financial and administrative burdens. So if what the person is asking for would require costs that would make the accommodations or resources of this just would not, there's no way for the staff or the provider to financially handle the cost of making the accommodation, then that's one reason to deny. That's permissible. Another permissible reason to deny services or housing would be it would fundamentally alter the nature of the provider's operation. So for example, if the person requests that the provider administer medication to a resident, or something like that, if there is no way in place already for that to happen lawfully, then that could be considered fundamentally altering the provider's operations. If they have to find a doctor or a licensed some licensed clinical staff that is otherwise not part of their services. However, something like requesting an assistance animal in a no pet building would not be a fundamental alteration. The third way that is a permissible denial of a request by an individual for an accommodation would be if something they're asking is a direct threat to health and safety. And this has to be based on objective evidence. So for instance, assumptions and fears are not enough. So if someone says that the dog in apartment 3A is a pit bull, which is an aggressive breed, that does not give you permission to say, no, you cannot have that pet. Instead, if someone says, you know, the dog in apartment 3 is exhibiting aggressive behavior by lunging at all of the children, then that would be something objective and a permissible reason to deny that request. Next slide, please. So when someone asks for a reasonable accommodation or a change in policy or a practice, the way to kind of think about this is to make sure that there is an actual relationship between what they're requesting and what they are saying is their disability, or what is preventing them from accessing the housing or services. So this really applies mostly to disabilities. And when you think about disabilities, one thing that is important to do is consider whether the disability is obvious or not before you start asking for things like documentation. So if the disability is obvious, you should not request additional information. So a resident who uses a walker requests a parking space near the building entrance. Both the disability and the need for the accommodation are easily observable. Whereas something like if the disability is obvious, but the need is not apparent, you can only request information that's necessary to evaluate the need for the accommodation. For example, a resident in a wheelchair requests an assistance animal in a no pet building. So you can see that there is a disability, but the need for the assistance animal may not be quite as obvious. Not every person in a wheelchair has an assistance animal. So there is room there to request medical documentation. So there's different verification options permissible, whether it's a letter from a healthcare provider, proof that the person receives Social Security disability benefits or other disability benefits. And it's important to note here that it's up to the requester which type of proof he or she chooses to submit. So that's the requester of the accommodation. They can choose what they submit. And a letter can be from any type of doctor, nurse, therapist, or social worker. Next slide, please. So this is the last bit on reasonable accommodations, but this is important because this goes to the what sometimes gets conflated in terms of what is a financial hardship for a provider. So when you think about modifications, modifications can include structural modifications. And what's important here is to remember that this is a change that's made to the existing premises that's for someone who is either already in place or who will be in place at that location so that they can enjoy the full use of the premises. So that could be anything from installing ramps, widening doorways, lowering light switches, adding grab bars or toilet extensions. And the thing to note here is that it's not sufficient just to say, well, that would be too expensive for us to do. the housing provider cannot charge a fee or be required to assess an additional deposit or ask for insurance from a disabled applicant or tenant as a condition of granting the accommodation. But the person who makes the request should pay for this. So what that looks like is in most leases, there might be a term that allows for those kinds of modifications to be made by the tenant, so long as the tenant returns the dwelling to its original condition, or so that it would not interfere with operations, or if it would be of benefit to a future tenant. The exception to this, when the provider must pay for the modification, is if it's a federally funded unit. Then the recipients of the federal funds, such as housing authorities, must pay for those structural modifications. Next slide, please. Okay, to kind of start wrapping this section up so that we have time to go through some of the other rules on topic. It's important to note that there are other fair housing laws on point that also prohibit discrimination. And some of these, for instance, Section 504 prohibits discrimination against persons with disabilities. The Civil Rights Act prohibits discrimination also on the basis of race, color, or national origin, particularly in programs that receive federal assistance. And then the ADA is another law that corresponds to state and local government activities and public accommodations there. Next slide, please. So, best practices. Based on all that we just discussed, the main takeaways here are that it's very important to make sure you get your staff up to speed on what is permissible and what is discriminatory. Ensure that all of your policies avoid those subjective determinations or practices that may limit access in a way that is discriminatory. And also develop a reasonable accommodation policy and make sure that all staff, particularly intake staff, are aware of it, so that there aren't mistakes on the front end about what the provider can or cannot do to make sure they can serve individuals from those protected classes. And finally, assess what your facility's accessibility is, and if possible, make whatever improvements you can afford to make. In most cases, your state law probably has already governed this, and most places will already be, up to code, so to speak. We'll talk a little bit more about what to do if later in terms of if you get a complaint, but for now, know that complaints and enforcement can be done by court filing. They can file a lawsuit, or administratively, they can file a complaint directly to HUD. So for more information on this, we've listed some resources here with links to them where you can find additional information to help with developing those policies and procedures. Okay.
We're also going to talk a little bit more for those of you who are case managers, where you're working with landlords in the community, about how you can approach that. That's part of kind of the last section of this presentation as well. What questions do people have? You can either unmute yourself or put it in the chat box. Excellent. Okay, we're going to move on to equal access then. I do have a poll on this one because the equal access has been something that there's been a lot of chatter about in the past couple of years. If you wouldn't mind responding to this poll about how familiar you are with the equal access requirements. It's the options are very, somewhat, or not very, or what's that? Just somewhat less than not very. Okay, huge variety. But we've got at least a couple not varies, so I'm just gonna go with that. So equal access. Over the past years, since 2012, HUD has published a couple of different rules and notices about equal access to housing. And the reason they did that is that there was research that showed that people who were lesbian, gay, bisexual, transgender, or anything in that realm were having a lot harder time accessing housing. And so specifically transgender and gender nonconforming persons were experiencing harassment and discrimination, were being discriminatorily excluded from shelters or facing dangerous conditions in shelters for those people. Some people even noted that when choosing between a shelter that was designated for their, the birth that was assigned to them at sex versus sleeping on the streets, that they felt more comfortable on the streets. And so HUD's put a couple of rules together to try and address this and give some guidance to anybody who receives this funding. So 2012, and these rules that apply to all of the CPD programs, the division of HUD, that's Community Planning and Development, I think. So it includes COC funding, it includes ESG, it includes CDBG funds. All of those programs have to abide by these equal access rules. So the first one was in 2012, and it defined family and gender identity and sexual orientation, and said that there should be equal access regardless of actual or perceived gender identity, sexual orientation, or marital status. And this is the first place where they defined family as being anybody who presents as family. And that if they present as family, you must serve them as a family. This rule also prohibited inquiries into gender identity or sexual orientation except for temporary shelter with shared sleeping areas or bathrooms. And then, so a couple of years later in the 2015, I'm going to do that first, 2015 notice, they were specifically focused on an appropriate placement for transgender person in single-sex emergency shelter. And then in there specifically said client should be based on the gender identity with which the client identifies. So not their perceived gender identity, what they say their gender identity is. And so providers may ask for a client's sex for purposes of appropriate placement, but there's nothing further than that, no documentation, and no disagreeing with it. So then why is there another final rule? Why 2016 at this point? And there's a few things 2016 rule does. First, it completely clarified that gender identity is wholly self-identified. Doesn't matter what the legal gender is, it doesn't matter what the identity documents is. Gender identity is what the person says for themselves. It prohibits intrusive questioning and requests for documentation very clearly, and it also requires updates to policies and procedures. So it's not just what you're doing, but that you have the policies and procedures behind it. It's part of the requirements of the 2016 rule. So getting into those requirements a little bit, and the key definitions to understand for this is gender identity is the gender that a person identifies with, no matter what they look like, what they might be perceived to be, what their sex was at birth. That's their gender identity, and that's the governing factor in determining how to house people. Perceived gender identity is what the person is perceived to be based on their appearance, their behavior, their expression, their clothes, what's in their documents. All of that goes under perceived gender identity, and that's what we don't look at. They define sexual orientation and family, any group of people residing together who present together for assistance and call themselves a family. So the 2016 rule said you had to have some program policies and procedures. And so that may require public posting of notice of the client's rights under the final rule. and they must ensure there's equal access to programs for all individuals, and that housing and services and accommodations are provided in accordance with a person's actual gender identity, and that eligibility is determined without regard to any of the other things, actual or perceived sexual orientation, perceived gender identity, or marital status. So it's important to have these policies and procedures because it sets expectations both for staff and clients. It provides really clear institutional guidance about how to do what we ask staff to do, and it sets a tone and a message of inclusion. Posting is a strong encouragement. It's not a requirement, but it goes towards these goals of making sure everyone's on the same page about what's required. Excuse me. The policies must state that providers cannot ask intrusive questions regarding an individual's gender identity, which includes anything like requesting documentation, physical or medical evidence, medical or physical history. That's all secondary. What gender do you identify with is the end of the story. So when you're thinking about like housing first stuff of lowering barriers, the less people have to show or prove to receive help, the less likely they are to sleep on the street. And so this is about a client-centered approach, and being just as quickly as getting people as quickly as possible into the housing they're comfortable in. So when there's facilities with shared sleeping or bathing areas, because this is kind of something that HUD's been dealing with for a while, placements are always made based on a person's gender identity. And so providers have to take steps to ensure that privacy concerns are addressed, and all that their policies are compliant with this rule. So what's that mean? So if a trans man comes up to a shelter staff member and says that he feels uncomfortable showering in the congregate bathroom because there's no stalls or curtains, then the appropriate response is to make changes to the showering area to ensure everyone greater privacy, not to ask him to shower at a different time than everyone else. There are multi-stall bathrooms and there's a single stall bathroom, and if the client's uncomfortable, ask why or what would make them comfortable and give them some options, which could include but aren't limited to using the single stall bathroom or using the bathroom at another time. And again, all this needs to be in writing. So in practice, if this isn't something that you've been doing for years and years, there's some changes in culture that are required. So of course, we've talked about being clear and consistent and making written policies and procedures, but it also requires things like training staff on what the procedures are, supervising and managing staff to help them start to implement it on themselves, communicating expectations to clients across the board, and then implementing the written procedures in response to harassment or safety concerns. So, and some other things you might consider are things like visual clues, like posting the policies or safe zone signs, or having other programming that supports kind of this culture change. Ensuring a safe environment. So the key thing the staff need to understand is language and using transgender inclusive language, and consistently use the correct pronouns and name, and use respectful and accurate terminology. Address clients' conflicts really quickly in a way that protects client privacy and ensures everyone's treated with respect. So if another client that has concerns about sharing a room with someone who they perceive to have a different, that their perception of the person's gender identity is different than the person's, taking that client who's got the issue into a different room, speaking with them privately, ensuring confidentiality for all of the shelter residents, and then dealing with the issue in a way that doesn't impact the person with that has this there's a perception that their gender identity is different. Accountability having, you know, written expectations and all those sorts of things, and confidentiality, which is really important. The clients, the sexes assigned at birth should absolutely be confidential client information, and that should not be information that's available to anybody else. So the appropriate question to use is, how do you identify your gender? Or another open-ended question, and letting clients know that shelter assignments are determined based on the gender with which they identify, and asking them what feels most safe to them. You can also use, are there any pronouns you'd like for me to use, is another appropriate question. Inappropriate would be asking for documentation, asking anything about history or their gender presentation, or any defense of their self-identification. A lot of buildings should consider maybe some physical accommodations like bathroom stalls with lockable doors and separate shower stalls, and having confidential spaces to have some of these conversations. So this kind of summarizes all the best practices of expectations have to be clear, there's written procedures, there's staff training, there's clear communication, making sure there's a safe environment, and making physical changes to protect people's privacy. That's the big part. And we also have these links, and we'll send out this PowerPoint so you can link to it from that. But HUD's done a lot of good material. So if you are training your staff and you want something really specific, things like the decision tree are really helpful. Let's see if I can switch to that really quick. Just to give, there's some great, there we go. This is what it looks like. You see it? Nope, probably not. There we go. So it gives some really good examples of encouraging and discouraging comments. And they also did a great training that provides different scenarios that you could talk through with staff that would be really helpful to understand how they might approach this if they're this isn't something they've been doing in the past. So just a few more things. Erica, do you want to talk about putting this all together, fair housing, the equal access, and the coordinated entry?
Sure. So how does this all connect? You can move to the next slide. The RNCoC has policies and procedures that mirror HUD's fair housing and equal access rules. They're in the policies and procedures, which are available to all of the participants and all the partners and stakeholders and providers in the COC. But it's important to note that the RNCoC also includes policies and procedures that make sure that everything from marketing to just non-discriminatory practices in general are also addressed. And so just to give everyone an idea, like the marketing piece, the fair and equal marketing policy, that is really similar to what we described in terms of the requirements around the Fair Housing Act and advertising, but it relates to coordinated entry. So what it essentially says is that the COC as a whole will market coordinated entry, as an access point without regard to specific subpopulations who are, or their protected statuses, and that the marketing will make sure to target and identify underserved populations, and marketing will be expansive enough to ensure that all eligible persons, regardless of their protective class, or any kind of perception of their race, color, religion, age, sex, gender identity, sexual orientation, disability, family status. And that that all resources will be made available in multiple languages and in a manner which makes them accessible to the individual. And the marketing campaigns will be designed to ensure that everyone has fair and equal access to the coordinated entry system. So that's your marketing policy. The real question becomes, and you can go to the next slide, Bridget. The real question becomes, okay, what happens if we receive a complaint? Or what happens if the complaint doesn't go to the provider, but it goes to the steering committee or to the housing matchmaker, or not to anyone in the COC at all? So it's important to remember that, number one, the RNCoC has a grievance policy, and that policy can definitely be followed for not just random things that come up, but also for issues related to fair housing and equal access. And the way that that policy is written, it requires that if a grievance comes to the provider must attempt to resolve the problem. And as you heard Bridget say, a lot of the methodologies that were kind of outlined under the equal access rule in terms of responding and making sure that the services or housing is accessible, is to ensure that things are done consistently, that things are in writing, and that everyone is aware of them. And so providers are encouraged to try initially on their own to work with the client if they do get a complaint, and to do it as soon as possible. If, for instance, the provider makes an attempt, or maybe the provider doesn't make an attempt, or if whatever is done is insufficient for the client then can take the grievance to the housing matchmaker. And this is all part of the RNCoC's grievance policies. So if the client isn't satisfied and or if there is some sort of conflict of interest with the matchmaker, the grievance then can go to the steering committee for a final decision. And that's pretty much where it will end there. But it's very important to understand that because these protections are federal laws and not just policies of the COC, clients have a right to file a complaint with HUD or a lawsuit in court. And the best defense is making sure that the provider and the COC's policies and procedures are very clear, and that the provider and the COC have done all that they can to try and address the concern as soon as possible in accordance with what the law allows. So the best way to kind of head off some of this is to make sure that everything is publicly available to clients. It doesn't necessarily mean you have to post it, but it does mean that if there is something that does come up, you make that available to the client so they can know, especially in the case of like reasonable accommodations or changes, you know, what kinds of things are permissible to ask for. You don't want a situation where there's a lot of back and forth and the provider never actually tells the client, well, look, if all you need is, you know, something to address this specific need, let's talk about what your needs are. So there's a conversation that should be taking place. Next slide, please. Now, this is something that has come up, and we've had requests to kind of talk about how to best respond to discrimination. And so if you see something, say something. You know, that's the rule. You need to ensure that the inappropriate practice is stopped. So that could look like intervention, like in the moment. It could look like reporting the issue to program leadership or housing matchmaker, especially if you're concerned about a problem but don't necessarily know how to address it in the moment. And also, you know, making an attempt to remedy the problem. And as most of you probably already know, you know, customer service is key, and apologies can go a really long way. And while apologies aren't sufficient to address discrimination, you know, making sure that that's included in kind of the whole package and plan of how to address the issue, that's something that's it's just a good practice to make sure you do. One thing to note is that the HUD COC Notice of Funding Availability, or NOFA, typically asks about the frequency of fair housing and equal access training. So doing something like this annually is also a good way to make sure that everyone knows not only how to respond to discrimination, but it's also a good way to ensure that when you get complaints, you can always point back to, or when there's even something as extreme as a lawsuit or a complaint to HUD, that, you know, we are working on making sure everyone knows the policies and procedures that are in place. So look to making reasonable accommodations and developing policies and procedures just as a starting point. And the biggest takeaway is that if you're concerned there may be a problem, talk it through with your program leadership and the housing matchmaker. The general rule is, if you don't think you could justify the activity or the policy that's in place to HUD under these rules, be safe and not sorry, and try and find a way to make sure things are done in an objective manner, and that they don't fall under these kind of discriminatory or no-no approaches. I just want to address one other thing, and I know I want to be respectful of everyone's time, but sometimes this is thought of as another way to remove barriers, either implicit or directly, in terms of responding to discrimination. So a good approach is to include the person who has been harmed in the, or is alleging harm to themselves, in the brainstorming process for possible ways to change the policy or activity. And Bridget alluded to this already. Let them know that they can submit recommendations for best practices to the housing matchmaker and the steering committee. And that's a good way to, over time, help develop and bolster the policies and procedures that are in place across the COC as a whole. But it's very important that those are consistent and known to everyone.
And then when you're responding to discrimination, if you're dealing with a scattered site project where you're dealing with kind of mainstream landlords and bringing subsidies to that housing, the fair housing laws apply to those people. The equal access, not so much. That goes to the recipients of the funding. So that's on programs. But fair housing applies to landlords and folks. And a lot of this still applies. So intervene, report it, attempt to address the problem. And it doesn't have to be an attack. It can be like very reasonable, like, you said this, that has a discriminatory impact. That's actually contrary to fair housing law. And providing just some background and information. You can pull a lot of resources from HUD's FHEO website, and educate and help them find the way forward, and give them the answer. And like Erica just said, you can speak with the person who was harmed about ways that could have been done differently that would help. It doesn't have to be an end to that relationship to tell them they're not doing it right, and to tell them what they should be doing better if it's approached in a helpful way. And of course, if they're actually really discriminatory and it's not an accident but intentional, certainly bring in the community stakeholders and people in the community, leadership at your organization or within the COC to address it more formally. That is what we've got. What questions do you all have? Can you see if there's any chats? All right, thank you for hanging with us a few minutes over time. And if you've got questions, definitely feel free to contact us. we'll send this out in the next couple of days, and our contact information is at the beginning. Have a great day.
Bye.